Don has helped hundreds of people for cleaning up their records and improve their prospects for getting better jobs and contributing to society. Occidental College and, Don has a BA in philosophy from Occidental College and a Juris Doctorate degree from the University of Southern California. Fight on! Woo! Don's office is in Torrance and he lives in Harbor City with his lovely wife, Caitlin, 3 dogs, and a cat. Please welcome Don Hammond.
Well, thank you, Stephanie Ann. I appreciate that introduction. And today we're going to talk about post-conviction relief. A lot of things are available after somebody's convicted of a crime. I strongly believe that nobody should be judged by the worst thing they've ever done. I don't think any of us wants to be judged by the worst thing we've ever done and have that follow us for our entire life. And a lot of people have the misimpression that once they're convicted of a crime, that's it. It's on their record for life. Their job prospects are hosed, and all they can do is wallow in self-pity for the rest of their life. That is not true. There are a lot of things that we can do after a criminal conviction to help the person clean up that record and move on with their life. So today we're going to talk about several of those avenues, one being early termination of probation. We're going to talk about how to reduce some felony records to misdemeanors under Penal Code Section 17B. We'll talk about petitions for dismissal or expungements. We'll talk about reductions under voter-approved Prop 47. We'll talk about certificates of rehabilitation. We'll talk about pardon options. We'll talk about sealing arrest records for people who are actually innocent but were arrested. Yes, innocent people do get arrested, and people who otherwise are not convicted but they still have the arrest on their record. We can go back and clean that up. And we'll talk very briefly about parole representation. So let's get started. For one thing, when people are on probation, a lot of misdemeanors in California, people are going to end up on 3 years of summary probation. That's a non-reporting probation. There's no probation officer. Terms would include obey all laws. In a DUI case, it would include attending some classes, paying some fines, those kinds of things. Now, once all those things that we call the affirmative obligations of probation are completed, we can very often go back and ask the judge to terminate probation early. So the fact of being on probation and having a conviction can hold up people's job prospects. It can stop them from getting promotions, and sometimes it can stop them from traveling. Most notoriously, Canada considers any DUI conviction to be a felony, and Canada will deny entry to somebody with a DUI on their record. And we can't do an expungement until somebody's off probation. So very often in these cases, what we need to do is go back and terminate probation early, get the expungement done early so that comes off their record, and then they can travel freely or get that promotion and move on with their lives. Once the termination is done, then we'll move toward a reduction if appropriate and an expungement. A felony reduction is most felony convictions in California are on crimes that are called wobblers. A wobbler is any crime that can be prosecuted as either a felony or a misdemeanor. It's the prosecutor's discretion. Very often they will file these cases as felonies, and as long as we don't have a state prison sentence, we can go back and have that felony reduced to a misdemeanor, so there's no longer a felony on the person's record. This has important implications for things like jury service, firearm ownership rights, and other things that it opens up, and it certainly helps open up job prospects for somebody to no longer have a felony on their record. And then even if we can't reduce it, if there was no prison time, the next step would be to go ahead and have the case dismissed. So this is sort of the meat of California's, people commonly call it an expungement. That word doesn't actually exist in the California Penal Code. It's a petition for dismissal. Penal Code Section 1203.4 authorize us to go back after a conviction, after somebody's off probation, on almost any misdemeanor and a lot of felonies. As long as there was no actual state prison time, we can go back and have the case dismissed. Legally, what happens is the conviction or the plea of guilty or the jury conviction is set aside, a plea of not guilty is entered, and then the case is dismissed. This allows somebody to legally, on any job application, especially private sector applications, they can say, nope, never been convicted of a crime. period, end of story. There are some exceptions for things like government background checks, licensing agencies. If you want to become a lawyer or a doctor or cut hair or sell real estate or any of the hundreds of other things that the California legislature decides the government should stick its nose into, and you need a license to do it, you'll still have to reveal it, but it should be, the fact that it was dismissed later on is a positive factor in their evaluation. Now, there are a couple of important things to note there also, is that under the California Labor Code, employers are prohibited from asking about convictions that have been dismissed or expunged. And under the government code, licensing agencies are prohibited from using a dismissed conviction as the sole basis for denying somebody a licensing application. So those are a couple of key important things for moving forward. Proposition 47 was passed by the voters back in 2014. It reduced a lot of drug felonies and theft felonies to misdemeanors, but people who had old convictions before 2014 have to file an application or a petition with the court to go back and have those things reduced. And it's important to get guidance from an attorney who understands this area, because there are differences in the results when somebody files a Prop 47 application for a reduction versus reducing it under 17B, the statutory reduction. And there are important differences in the rights that are restored. So it really helps to have a qualified attorney help with that situation. There are some restrictions for the felonies that are reduced. Consult an appropriate attorney. There's a deadline though to have these things reduced. That's November of 2022. Initially, it was, I think, 2018. They keep extending it, but we can't count on them doing it again. So it's important to talk to an attorney early, get these things done ASAP, and get these reductions in before the time expires. Now, people may be thinking, well, that's great for people who didn't serve state prison time, but what if I did? And that makes me ineligible for a reduction under 1203.4. What is available for somebody who did serve state prison time on a felony is a certificate of rehabilitation. Generally, for a certificate of rehabilitation to be eligible, you're going to have 7 years of clean time. So since you're off probation or parole, or since you were released, since the last custody event, you have to be off for 7 years minimum, and you have to have lived in the state of California for the last 5 years. So sometimes we run into people who have moved out of state and they say, well, gee, I've been clean for 10 years and they want to do a certificate of rehabilitation, and they're not eligible unless we can find a way to show that they've been living in the state. And the DA will conduct a thorough background check on these. These are not super simple applications. They're pretty complicated. It enhances potential for licensing. It does relieve some sex offenders from registration. And the awesome thing about a certificate of rehabilitation is if that's granted, it becomes an automatic application to the governor's office for a pardon. And this is the pool from which the governors have historically granted the most pardons, as people where the courts have already granted them a certificate of rehabilitation. So that's a very powerful form of relief. They would still have to say on an application that they had the conviction, but they can say, yeah, but a judge said I'm rehabilitated. And then if a pardon is granted, which I think is the next slide, if a pardon is granted, then that restores the rights to serve on a jury. It can restore firearms rights in certain types of cases. If the crime was gun related, it's not going to though. It can make people eligible for government appointments again, governor's appointments. A lot of people with felony convictions are ineligible to serve in various committees and positions in the state government. And after a pardon, they're eligible again. So it's an awesome thing to be able to say, yeah, I got a pardon from the governor. That's really helpful, and it may even prevent deportation for somebody who has a conviction and the federal government is after them to get them out of the country. So this is certainly a powerful avenue of relief. Record sealing applies in a couple of distinct circumstances. For a long time, California's only sealing mechanism was if somebody could prove their actual innocence. You'd have to go into court and prove to a judge that either they arrested the wrong person or by some other means that you didn't actually commit the crime. That's a pretty high standard. It turns the burden of proof in our justice system on its head. You know, normally the government has the burden of proving beyond a reasonable doubt that you did do the crime. If you want a factual innocence finding by a court, you're going to have to show that you did not commit the crime, which is very difficult. Fortunately, the beginning of 2019, a law went into effect that allows people to have their records sealed if there was no conviction. So if there's an arrest, but no case is filed, or if the case is filed and later dismissed, or if there's a diversion that results in a dismissal, there's no actual conviction in the case, we can go back and have those arrest records sealed. That's about to happen with 3,000 people or so that the LAPD and surrounding authorities arrested on failure to disperse, protesting type charges, and curfew violations, where the district attorney's office and the city attorney's office have said that they're not going to file the cases against people who had those arrests. They were given citations, they were given notices to appear in court on a particular day, but the case is not actually going to be filed in court. But these people all have that arrest on their record now that can show up and cause them problems. So a year from the date of arrest, they should all go back and file petitions to seal the arrest records so that that arrest won't even show up on a background check. And it really helps them down the line to be able to say on an application, nope, never been arrested for anything. Thank you very much. It's a powerful form of relief, and it's something that a lot of people will forget to do. So in particular, if you know anybody who was caught up in the recent protesting arrests, curfew arrests, send them on over. We'll be happy to help with those sealing applications and get their records cleaned up. Parole representation. I've been doing this since I was in law school in USC's Post-Conviction Justice Project, working with a couple of great professors there. This applies to lifers, so people who have been convicted of a very serious crime. They've been sentenced to 15 to life or 25 to life, or some other variant of a sentence where there's a to life on the end. They have to get through the parole board to ever come home, and preparing people statewide, whatever prison they're in, I'm happy to go meet with them multiple times, help prepare them for that hearing, help them understand the types of questions that are going to be asked, help them understand and help them do the work to be able to answer those questions honestly and authentically and really be ready to come home. The ultimate standard in these hearings is that parole shall be granted unless there's some evidence of present danger to society. So we're always trying to make that showing that there's no evidence of present danger to society so that these people can come home, get on with their lives, help others avoid making similar mistakes, and become productive members of society. There are a variety of factors that we consider. If you know somebody who's in this situation, send them on over. We're always happy to talk about it. So things to listen for while you're out and about talking to your clients, your friends, your family. I was arrested 10 years ago. If they were arrested 10 years ago, whether they were convicted or not, we can sort of triage that, figure out what's the appropriate relief, whether it's an expungement of a conviction, whether it's a certificate of rehabilitation for a state prison term, whether it's a record sealing. If there was no conviction that arose from that arrest, we can go ahead and pull the records and figure that out. I always do the evaluation absolutely free of charge to figure out what they're eligible for. And then once we know what they're eligible for, we can talk about what it's going to take to get it done. Somebody might say, I'm looking for a job, but this old thing is holding me back. It keeps coming up on my background checks, and we're happy to go back and get those things cleaned up. If somebody has a loved one who's trying to come home from prison, they want to talk to somebody about that process. I've done dozens of these. Like I said, I started them while I was in law school. Always happy to talk about it. People trying to get licensed, going ahead and cleaning up their background is really helpful in the licensing process for, cutting hair, becoming a security guard, selling real estate, becoming a dentist, all the many, many things that California requires licensure for. We want to do that. So anything where somebody's being held back, anybody who's ever been arrested in their life, they should call their hero at 888 DUI HERO, and we can certainly help. I see that there were a couple of questions or comments here. Ismail has asked, if you pay your fines and fulfill your obligations, you can get a felony removed as long as there's no jail time. So generally that's true. Even if there's jail time, if it's county jail, it's going to be eligible to go ahead and get that cleaned up. If it's state prison, then we have to do the next level up process called the certificate of rehabilitation. But even if it's a felony with county jail, even under California's realignment law that happened back in 2011 or 12, where they started doing state prison Sentences to county jail, so you're actually serving what they call county prison under Penal Code 1170H. We can go back and clean those up. As long as they never set foot in a state prison, the process is on the much simpler version of a petition for dismissal. If there is a state prison, then we have to upgrade to the much more complicated process, which we're also happy to do. We have at least one of those pending right now with a hearing in August, and we're going to get that granted, and it'll act as an application for a pardon. So there are a lot of great things we can do there. The state will, Kathy has a question here, will the state allow you to vote after a conviction? Yes, California recently changed the law that almost any felon can vote now. Regardless of state prison time, regardless of what happened. And some people can vote from in custody. I don't know all the details on that. I'd have to look it up. But certainly once people are released from custody, almost everybody is eligible to vote in the state of California. If there are no other questions here, we'll go ahead and wrap up. Thank you very much for your time.